If you own property on Anna Maria Island or Longboat Key, or you're thinking about buying here, there's a Florida property tax proposal you need to understand. The headlines mention a $250,000 exemption, but does that apply to your home, your vacation rental, or your investment property? Let's break it down. In June 2026, the Florida legislature approved a proposed constitutional amendment called Save Our Homes from Excessive Property Taxes. But legislative approval does not make it law. Florida voters still have to approve it. So this is a proposal, not a tax break you should assume is already in effect. For qualifying primary residences, the proposal would increase the non-school homestead exemption to $150,000 beginning January 1st, 2027, and $250,000 beginning January 1st, 2028, with future inflation adjustments under the proposal. That is an exemption from part of the property's assessed value, not a $250,000 check, and not an automatic $250,000 reduction in your tax bill. School district levies are excluded from this new exemption. If your Anna Maria Island or Longboat Key property is your qualifying Florida homestead, the larger exemption could potentially matter if voters approve the amendment and it takes effect as written. But the word qualifying is important. Owning real estate in Florida does not automatically make it a homestead. Vacation rentals, second homes, and investment properties are different. If a property is not your qualifying homestead, do not assume it receives the $250,000 homestead exemption. For certain non-homestead properties, the separate assessment growth provision may be more relevant. The proposal would reduce the annual assessment growth limitation for certain non-homestead real property from 10% to 5%, beginning January 1st, 2027. But the details matter, and a change in ownership can cause a property to be reassessed at just value before the limitation applies again. A seller's current tax bill is not necessarily a prediction of a buyer's future bill. For someone who already has a Florida homestead and moves to another Florida homestead, the proposal includes a new assessment rule that could allow a difference of up to $500,000 between just value and assessed value, depending on the requirements and formula. That is not a $500,000 property tax exemption. New Florida residents should also pay attention. The proposal does not necessarily provide the full $250,000 exemption immediately. Under the enrolled proposal, someone establishing Florida residency after the applicable cutoff would initially receive a $50,000 exemption for non-school levies, with eligibility for the larger exemption after the specified period. For a condo, the answer depends on how the property is owned and classified. A qualifying homestead could be treated differently from a second home, vacation rental, or certain non-homestead residential property. The key question is not simply whether you own a condo in Florida, it is how that property is classified for property tax purposes. There is also a local services question. Property taxes help fund public safety, roads, stormwater infrastructure, flood control, and other government functions. For coastal communities like ours, changes in property tax revenue could affect local government finances and services. The question is bigger than just how much an individual owner might save. The bottom line is this: qualifying Florida homesteads could potentially see a larger exemption if voters approve the proposal. Vacation rentals and investment properties should not assume they qualify for that homestead exemption. The proposed 5% limitation may be more relevant. Buyers and sellers should look at the actual numbers for the property, because classification and ownership history matter. I'm Amy Jones with Coastal Key Realty. For help understanding property taxes when buying, selling, or investing on Anna Maria Island or Longboat Key, call me at 941-993-9380. I can help you review the real estate numbers and point you to the right property tax resources.